that has been moved by Mr. Manish Sisodia seeking quashing of his arrest that was done by the CBI. The Supreme Court has begun hearing on that matter. This is right after the Punjab matter was heard. A bench led by Chief Justice of India, Justice D.Y. Chandrachud, is hearing this entire case. In his petition, Mr. Sisodia argues that the manner in which the agency carried out the arrest was not in accordance with the proper procedure, and there are no grounds of arrest that have been made out. This petition is lined up before the Supreme Court right after the trial court or the local magistrate court granted a 5-day custody to CBI of Mr. Manish Sisodia. Well, one thing to note here is that this is not a bail application. This is not a bail petition that has been moved. This particular petition by Mr. Manish Sisodia is directly questioning his arrest. Earlier, his lawyers in the court also yesterday had said that, look, there is a law of the land that under Article 20, you cannot be forced to give self-incriminating evidence. The accused, like in US and other constitutional countries and democratic countries, has a right to silence, and merely on the basis of silence, you cannot arrest somebody. The argument of Mr. Sisodia has been that he's cooperated in the investigation so far, and it is only out of political compulsions that CBI is acting. Well, whether any of these arguments are accepted by the Supreme Court today is a matter of wait and watch. Usually in matters of this nature, when the trial is underway, a charge sheet is to be filed, CBI is investigating a matter according to due process. The courts are very circumspect in terms of interfering in matters like these. The hearing has begun in the court. The Chief Justice of India goes on to say that you have a remedy like bail in the competent court, 482 of the CRPC. There are also judgments of Vinod Dua and Arnab Goswami that have been cited where the court took the extraordinary effort of protecting the constitutional rights of an accused. Then you have Mr. Abhishek Manu Singhvi, who's arguing the matter. Anshul is also with us on the broadcast. Anshul, the arguments are going on at the Supreme Court, and Mr. Manish Sisodia, through his lawyer, goes on to say that each time he was summoned by the agency, he deposed before the agency and has cooperated so far.
Well, definitely. So the arguments are the same as what we saw happen yesterday inside the Rouse Avenue court. In fact, in front of this CBI judge and Abhishek Manu Singhvi, who is arguing on behalf of Manish Sisodia in this entire matter of the Aam Aadmi Party. He's saying that whenever Manish Sisodia was called for interrogation, he has come and joined the investigation, and he's saying that arrest is illegal because according to the CRPC, the maximum punishment is less than 7 months, and hence he is reading this with the section 41A with Anish Kumar and Andal judgment that there has to be a triple test to be satisfied, and allegations of multi-level decisions on excise policy, it will send a wrong precedent, is what Abhishek Manu Singhvi is saying. So yes, okay. The hearing has begun at this point in time. It is in its initial phases. However, the first comment that came from the CJI was actually very, very interesting, where the CJI had said that you already have the remedy like bail to go before the competent court, which is the Delhi High Court in this entire matter. But yes, Singhvi has again cited that precedence where the court has taken this extraordinary effort to come out with remedies and give relief to people in such cases.
As I was earlier arguing, this is not a bail application. The remedy of a bail under 482 of the Criminal Procedure Code would lie before the Delhi High Court. The petition at the Supreme Court right now is seeking quashing of arrest. Mr. Sisodia argues that whatever offences he's been charged with, the punishment for those offences is less than 10 years. And Section 41A of the CRPC, read with the Anish Kumar judgment and other judgments of the Supreme Court, lays down that if an accused is cooperating in the arrest so far, in the investigation so far, then arguably there are no grounds of arrest which are made out. That's what Mr. Sisodia is arguing. Yes, we'll hear it from the other side as well, what the agency has to say. You also have the Vinod Dua judgment which is being cited. Arnab Goswami, when he was arrested, there was extraordinary effort that the Supreme Court had taken and said that dissent has to be allowed, liberty has to be allowed and protected in this country, and taking an extraordinary measure, bypassing the entire procedure of the High Court and the trial court, the Supreme Court had granted relief to these individuals. All of those judgments are being cited in the court right now. Arunima is also with us on the broadcast. Arunima, the arguments underway at the Supreme Court.
Yes, and like you've already pointed out, the two cases that are being cited by Abhishek Manu Singhvi, the Vinod Dua case and the Arnab Goswami case, the CBI would want to draw a difference in the two allegations. where in this case the charge is of corruption, Section 7 of the Prevention of Corruption Act, sections of 120B and 477 of the IPC, and Mr. Sisodia being named as the main accused. The charge against him is that he got into a conspiracy with the other accused, caused a loss to the exchequer. CBI alleges that 100 crore was paid as bribe for the changes that were made to the excise policy. This case is very different from what was alleged in the Arnab Goswami case or in the Vinod Dua case. There the allegation was that dissent was being stifled. Here the CBI would want to make a distinction that the charges are different. But as we are speaking, what the Supreme Court has told Mr. Singhvi is now reading out the Vinod Dua judgment. But just before that, Justice Narasimhan actually said that if this is allowed, it will send a wrong precedent. Just because it is happening in Delhi doesn't mean that the law can be different, is what Justice Narasimhan said. There was also a comment made that you have the remedy of bail available. This is not you coming to the Supreme Court to seek bail, because if that was the case, then the adequate forum would have been the lower court and then the high court, and then you would have knocked at the doors of the Supreme Court. But this is not Mr. Singhvi representing Mr. Sisodia seeking bail for him, but calling the entire arrest illegal. Now, I have been speaking to CBI officials. They are very confident that the remand note that they put up in the Rouse Avenue court yesterday, that has details about why they wanted Mr. Sisodia's custody. They are quite confident that they need to confront Mr. Sisodia with the approver in this case, Dinesh Arora, the alleged associate of Mr. Sisodia, who reportedly has confessed before CBI how Vijay Nair, the main accused and alleged main associate of Mr. Sisodia, actually got into conversations of 30 crore rupees kickback and to be paid immediately upfront, and 100 crores overall kickback to be paid in advance. All of these conversations have been given to the CBI by the approver in this case, Dinesh Arora. They need to confront Mr. Sisodia with these documents, files that have been recovered. They need to ask him as to why is it that he told his then secretary to print the excise policy in a particular way and to make that turnaround of 12% of profit margin. Why were all of these done? They need to ask Mr. Sisodia this while presenting evidence, documents before him, is what led CBI to take him into custody. CBI and in this case, Tushar Mehta would want to impress that point before the Supreme Court.
Whenever offences of this nature are put against an accused, the agency has a right under the Criminal Procedure Code to take the accused into custody. Yes, there must be plausible grounds of arrest. And the court, like yesterday, the magistrate court or the lower court where you're presented within 24 hours of your arrest, can deny the custody to a particular agency, including the CBI, if there is no case at all which is made out by the agency. As my colleagues were arguing, there are multiple accused in this case, especially Dinesh Arora, who has turned into an approver. There are testimonies of various bureaucrats on record, various loopholes that have been cited by the agencies, multiple questions that were posed to Mr. Manish Sisodia, on which he did not give satisfactory response. So far what emerges in the case, and this is what is important at this stage, that prima facie there should be some degree of substance to the allegations that have been made against the accused. Hence, the sense that Arunima was picking up from the CBI officials, that they're pretty confident about the case at this point in time, that the arrest is not without its merit. When Mr. Manish Sisodia or anybody goes to the Supreme Court, that they have a right to say that, look, my Article 21 rights have been infringed upon, the arrest per se is illegal, the court will look into all of this. But there's an oral observation which is coming in from the bench right now, which says that, look, it will be improper to intervene in this case at this point in time. The criminal investigation is underway. 4 accused have been arrested. 2 charge sheets have been filed so far. With the arrest of the Manish Sisodia, it is also expected that yet another charge sheet is going to be filed. As I said earlier, mostly the constitutional courts, including the High Court and Supreme Court, are very circumspect when it comes to intervening in ongoing investigations of this nature. And yes, the cases are very different. If you compare the case of Vinod Dua or an Arnab Goswami with what is happening in Manish Sisodia's case, this involves public exchequer money and a loss of about 2,000 crore rupees that has been cited by the agency. Arunima, prima facie, these are